Good morning. Today is January 27th, 2025. And today I wanted to talk about the idea of how to be an effective dual agent. So, in order to do that, I'm going to be referring to Form 41 and Form 1A, as well as the purchase and sale agreement. So, when it comes to being an agent, we have our agency relationship with our clients, and we need to know what that means as far as our duties and what we owe to the parties that we represent and what we owe to the parties that we don't represent. So, just as a quick overview, what we owe to all parties, whether we represent them or not, is the idea that we will exercise reasonable skill and care. We will be honest. We will present offers timely. We will disclose material facts. Any money that we receive, we will be accounting for. We will provide the pamphlet that shows these duties to both of these people. We will disclose everything in writing as far as who represents whom. And we are going to disclose in writing the terms of our compensation as part of our real estate duties in the firm we represent. And this will be shown to either party. Now, we do have limitations when it comes to being a dual agent, because when we represent a specific party, such as a buyer or a seller, we are doing so by gathering some confidential information. And that information is what we need to keep between us and our client. So, what happens when we do represent somebody on either side of the transaction? I know in the past we've used examples of, you wouldn't necessarily go to court and fight a court case when you have the same lawyer that represents the defendant and the prosecutor, right? So, you wouldn't necessarily go into a courtroom with one lawyer to fight two separate sides. And just as that, you wouldn't necessarily have real estate transactions on a regular basis that one person is going to be acting on behalf of both parties. We have a duty of confidentiality, a duty to work in our client's best interest. So, how does working in the best interest actually happen when we have two clients that we need to work in the best interest of? Specifically, this comes into consideration when we talk about contract negotiation. This can come into consideration when we can talk about pricing, maybe somebody's bottom line, or even when it comes to negotiating repairs, the knowledge that we receive from one party versus what we learn and need to disclose to the other party. So, when we act as a limited dual agent, we need to follow these 5 basic rules. And this is laid out in our agency pamphlet that we give these clients. So, the first one is to take no action that is adverse or detrimental to either person. So, we have to be acting more as a mediator and less of an advocate. We're not going to be advocating, we're going to be just facilitating. Number 2, we do need to timely disclose that both principals do have a conflict of interest when it comes to us representing both of them. They both do need to be aware of this, and it does take written permission in order for you to make this happen. We need to advise both of the people we represent, because in this situation, we do represent both people, that they are to maybe seek expert advice on anything that is beyond what our scope of expertise is. We cannot disclose confidential information about the other person to another person. And the 5th one is to make a good faith and continuous effort to find both the buyer and our seller somebody to purchase their property. So I want you to think about that idea and then think about the idea of being on a team. Now, if we were on a team and one of the team members discloses information about a seller, are other people from that team obligated to keep it confidential? Who would represent the seller, or would you represent the seller at this point? So you have a team member, say maybe your team leader or a member of your team is representing that seller. You, as part of the team, hear information that is supposed to be confidential with that seller. What can you say? What can't you say? And who do you represent? Well, if you've answered this in your head, there's nothing that creates an agency relationship between you and the seller, even if a team member has a contract with the seller. If you do not have that contract, you don't represent them. So you would represent a buyer, and thus any information that was shared could be shared from you to your potential buyer without any violations. So be careful what you share if you have a team, especially if you're sharing it with somebody who doesn't have a written agency relationship with the client you're talking about. In order to do all of this, we do need to have everything in writing, and we need to have consent from both parties to act as a dual agent. I have here on the top the buyer agreement and on the bottom the seller agreement. Both of these are required to be initialed by your client if you are acting as a dual agent. They need to consent on the listing side and they need to consent on the buying side. Now, when it comes to actually putting in the compensation, this is the part where people get the most confused. So I wanted to color code this just as a reminder that we are looking at compensation as two separate parts. We're looking at as a buyer compensation and a seller compensation. Sorry, buying agent and selling agent compensation. So in the pink, I did a buyer's agent compensation of $10,000, and in the green, I did a seller's agent of $10,000. Now, in this particular example, we will be looking at these two numbers here to figure out what a dual agent would be paid out in the event that it happened with this contract in place. So in this contract, a dual agent would receive what is in 7A and what is in 7B paragraph II. If there's nothing written in 7B II, there is a default option. So what about if there is nothing written right here? If you remove it and have nothing down there, then it refers back to what a buyer's agent would have been paid if there was no difference in that compensation. So in this example, the $10,000 for the listing firm would be paid, as well as that agent bringing a buyer for the already decided buyer broker compensation offer of $10,000. Again, when we put this on our purchase and sale agreement, though, we need to make sure that what's being offered is actually what we're planning on being paid based on how we fill out 17A and B. What about in this example here? So in this example, we have a listing compensation of $10,000, a buyer broker compensation of $10,000, but if no one else brings a buyer and the listing agent finds a buyer, there's a discounted price of $5,000 for the buy side. So how would that be calculated? Well, we look at the $10,000 for the listing side, and then what the dual agent compensation would be if that agent also brought the buyer. And in this case, it's $5,000. So the total paid to this dual agent would be $15,000. This example shows the listing side at $10,000. If a buyer broker brings another agent or another buyer through, that buyer broker gets $10,000. But if the listing broker finds a buyer, they're asking for $20,000 more dollars. In this example, with those numbers written in the places that they are, that listing agent acting as a dual agent would receive $30,000. This is actually two separate columns of payment. So if you are acting as a dual agent, it's going to be the listing compensation plus whatever you put in for the dual agency. The dual agent compensation in 7BII is never going to be the combination or the total. It will always remain as two separate pieces. Now let's talk about the buyer for a second. The buyer is going to fill out your buyer agency agreement. Now, in the first line of compensation options, it just has the amount that's going to be paid by that buyer should the seller not be offering any if you find them a home. Now, if you're just dealing with the buyer, it's not required that you have the dual agency signed. In paragraph 5A is going to be what we've kind of normally done. This is one of our more routine type places to fill out this paper. Now, if you are putting any number in section B, it's required that you do have that initial for the consent for dual agency. Keep in mind too, dual agency for the firm is something that is an automatic acceptance. There's no additional consent required because if any of the managing brokers are acting as a dual agent because of how the firm is situated, it's automatically letting that client know that we may be acting in a supervisory role. Now, when it comes to the compensation for dual agency, here's where you can put your number. I just did an example of $10,000, put it right in that place. Now, this just means in the event the seller is also consenting to dual agency, you can ask for that seller to pay this amount of money. We're going to talk about how we compare that seller contract versus that buyer contract and how we match up those numbers in a minute. Again, if this box is checked, you need to have the initials by that buyer consenting to do so. Initials are not required for the third option, which is basically like your buyer finding a for sale by owner. But the consent for dual agency is not required because you are not a dual agent. You are only representing the buyer in this case. So disclosing our limited dual agency, how do we do that? And how do we do that in an effective way? Well, on our purchase and sale agreement on line 16, this is where we disclose who we represent. So remember, in order to represent a buyer and seller as a limited dual agent, you need to have a buyer contract signed with consent and a seller contract signed with consent. If you don't have both of those things, you cannot be a dual agent. You can only represent one party if you have that party's agreement signed. Any offer of dual agency compensation has to be put down in 17A because one of our duties in our agency law says that we are going to disclose any offers of compensation in writing. That's what happens in 17A. Now, if your dual offer of compensation is $20,000 because that's the amount the agent's going to get for buy side and sell side, then that would go right here, $20,000. Those numbers are the total that a dual agent would receive. And then on 17B, this is going to be the amount that the seller pays. The seller could have offered in the listing agreement to pay $20,000 to a dual agent, $10,000 for the buy side, $10,000 for the sell side. If that's the case, $20,000 would need to be listed in 17A. Now, that buyer also has an obligation to pay that agent if they're a dual agent. And if that $20,000 is not enough to cover what they've promised to pay their agent based on their contract, then this is where we get to negotiate that part. We're going to think of it in the same way as buyer compensation being offered versus what our buyer broker agreement says. So we need to make sure that the number in 17B is going to be the same that our buyer agreement says, if not at least the same as our listing agreement, so we know who's paying for the money, where it's coming from, and everybody knows how much is getting paid and how much is being offered. So as a final sort of wrap-up thought to these, are these numbers the same? And what happens if they're not? We're going to talk about some different scenarios when it comes to what happens if the seller offers $5,000 in dual compensation, but your buyer said that they would pay 10. How do we come through with that difference? What happens if it's more money? What happens if the seller says, I'm going to pay 20,000 and buyer, you were only on the hook for 10. So, are we good to go? What's going to happen at that point? So when you think about these lines 17A and B, think of these offers of seller compensation just as you would a normal listing agreement when you're not a dual agent. The seller has an offer to pay for the dual agency in a certain number that they have with their listing agreement. Any downward adjustments need to be made after mutual acceptance, or they can be made after mutual acceptance. Any upward adjustments cannot be made. You can't all of a sudden charge more money. You have to deal with the numbers that you have in place. And if any upward movement does need to happen, make sure you do that before you even start drafting an offer, because those also come along with conversations to your client and explanations that you owe to them. I appreciate you tuning in today. If you have questions specifically about numbers when it comes to compensation, you can reach out to me directly. I'm happy to go over different scenarios